Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and this is the first in a series of Knowledge November sessions where I'm going to be talking about the new law that we're all going to be tackling on shared parental leave. As I said, it's going to be a series of sessions. This first session, we're going to look at eligibility and some of the background and the basics as to how it's going to work. In future sessions, we're going to look at things like the mechanics and issues around pay and returning to work and all of those sorts of things. Throughout November, I'm offering people the opportunity to email their questions about this topic area to me, and anyone who does that and subscribes, I'll circulate all the answers to them. So let's kick off and think about this new legislation. Up until now, we've had a situation where typically mothers have taken maternity leave, fathers have been able to take 2 weeks ordinary paternity leave, and if the parents have been eligible, there has been the facility for a period of additional paternity leave to be taken by the father on the proviso that the mother has returned to work. So this is really an extension of that and changing that a little bit. The idea is to give parents more choice and flexibility, but it is worth emphasising that this new scheme is optional. Parents certainly don't have to go down this road. I suspect there will be many women who still will cherish the opportunity to take a year off when their baby is born, or indeed if they're adopting, and we may not get into this territory at all, but it is important that employers start to publish the details to employees. I would say sooner rather than later. I'm already starting to see queries coming in from new parents, people who are likely to be adopting, where they've heard about this and they perhaps don't realise that it's not actually going to affect them yet. So there's some confusion. So I think the more that we can tell people, the sooner the better. In terms of when this is going to come into force, the law itself comes in on the 1st of December of this year, but it doesn't kick in terms of babies who are born until April of next year, and matching for adoption from the 1st of April of 2015. So the important bit about the legislation coming in December is that it protects employees who might be inquiring about how the scheme is going to work into the future. So for example, if an employee in the middle of December was to inquire about the scheme and found themselves being treated detrimentally by their employer as a result of doing that, or even finding themselves dismissed, then the legislation is already there from the 1st of December to protect them. It would be an automatically unfair dismissal if an employer did dismiss somebody for saying perhaps they were interested in this scheme in the future. It's worth emphasising again that the scheme is optional. Parents do not have to use it. They can rely on traditional adoption leave, maternity leave and parental leave. So it's going to depend on different employees, I think, as to whether or not they're interested and whether or not it's relevant to them. In terms of eligibility, starting point is we've got to have some parents. In terms of the way the law is framed, it's very much around the parents who are going to be caring for a child. So I can foresee a situation where there might be a birth father who is no longer involved with the mother, and maybe she's got another partner who is actually going to be responsible for the care of the child. In that circumstance, it's the parents who are providing that care and in that enduring relationship that will qualify, not the absent parent, if you like, who may not be having a main responsibility for caring for the child. I think it's going to get more complicated if people have very grown-up relationships where there is a lot of sharing of the responsibility, even though people might not, for example, be living together. key qualification from women's perspective is going to be having 26 weeks service to be eligible. Other than that, paradigm situation, of course, is going to be two parents, both employed for organisations. That's not always going to be the case, though. As long as the parents being economically active in recent times, then they may well qualify. So, for example, you may have a parent who has recently been made redundant, or you might have a parent who is self-employed. Just because they're not both working for an employer at that point doesn't disqualify them. It's the same test that's used for example, whether somebody qualifies for maternity allowance. If somebody's been economically active in 22 out of 66 weeks in the lead up to the expected week of confinement or the matching for adoption, and in at least 13 of those weeks they have earned £30, then they will qualify. So, for example, you could have a situation where the mother is in work, maybe the father is, I don't know, a self-employed artist. As long as he's actually been selling some of his artwork, it may be that that family decide that they want to use the scheme so that maybe she can go back to work and bring in perhaps the higher income in the household, leaving the father to perhaps engage in the childcare. The opposite, of course, could also apply as well. The scheme assumes that the first 2 weeks of a period following a birth or an adoption, that the primary adopter or the mother will take maternity leave, compulsory maternity leave as it's known, or that the primary adopter will take two weeks as a bare minimum of adoption leave. After that, it's really flexible for the parents. As long as they qualify, they can decide how they want to divvy up the remaining 50 weeks. Now, there will be cases where, for example, it's beneficial for the mother to stay on maternity leave and perhaps qualify for an enhanced payment from her employer. That's fine. They can choose to curtail the maternity leave, and we'll see in the next section, the next session, how important curtailment of that maternity leave is. That they're entitled to say when they want that period to cease, and whatever is left basically becomes what's there to be shared between the parents. Now, when I say shared between the parents, it can be shared in blocks, although we'll talk in more detail in another session about how that would work. It can be both parents taking this time off together or consecutively. It really is up to them, or it could be one continuous block that they're interested in taking. But we will look at that in future sessions. If anyone's got any questions rising out of today's session, please do email me adenton@refreshinglawltd.co.uk. Thank you very much.